Hi, I am pleased to meet you. My name is Myung-Ju Kim. I have been researched and taught IT, especially information security at Seoul Women's University. When we liken ethics to the sea, regulations can be likened to a ship. If these discussions on ethics get matured in society to some extent, mandatory regulations are enacted at the minimum level. Current AI regulations have been implemented in very specific areas. In other areas, regulators are devising proposals. In this lecture, we will examine regulations on AI as the next step to AI ethics. Let's briefly look at what we are going to learn in this lecture. Among AI technologies, deepfakes have produced enormous side effects and dysfunctions. So, USA and Korea have enacted the laws to minimize such adverse effect. In April 2021, the European Union Commission devised and proposed the world's first AI Act, simply AIA, as a law covering the entire AI systems. This act classifies AI systems from the perspective of risk and presents the required regulations and penalties. In this lecture, I hope you can understand these 5 ideas. And in this lecture, as you can see on the screen, we will learn these 4 topics in order. Deepfakes, AI-based app first released in 2017, became out of control. So severe that it was impossible to prevent their side effects only with ethics. Deepfakes were used extensively and maliciously in celebrity pornography and revenge porn by a partner, fake news, and scams. In particular, porn production using deepfakes was about to spread like an infectious disease. This led to an explosion in defamation, sexual exploitation, cyberbullying, and frauds. As a result, people raised voices about the need for legal regulations of deepfakes. In June 2019, a GAN-based deep nude app was published to completely remove clothes from images and videos of ordinary women. Deep nude were available as paid and free version at the time. The paid version costed $50. However, after facing much criticism, the developer took the deep nude app offline on June 27 of that year and refunded customers who bought the paid app. However, deep nude is still being distributed on torrent P2P sites and dark websites. In many cases, such illegal distribution helps distribute malicious codes as well. Deep nude defames victims and at the same time incites voyeurism among its users. Deep nude can be seen as a full exploitation of deepfake. CTGAN is cited as an example of deepfake technology applied to 3D medical information. CTGAN was unveiled in 2018. It changes the 3D biometric image information of a specific patient stored in the medical information system of a hospital or medical institution. For example, using this CTGAN, you can insert or eliminate cancer traces from 3D images of a patient lungs. CT scan manipulated false results are also realistic that even medical doctors can hardly distinguish them. Like this, hackers can use the CT scan to forge health information of a specific person and commit insurance fraud. Deepfake legislation was introduced by US Congress in 2019. Shortly ahead of the 2020 presidential election, the US Congress introduced the Deepfakes Accountability Act to legally hold people accountable for using deepfakes. Using deepfakes itself is not prohibited in order to guarantee freedom of expression. But for content created using deepfake, you must disclose in the disclaimer that it is false deepfake content. And it is also illegal to remove such disclaimers. But there are exceptions that apply only to very limited cases, such as records produced by the government. In June 2020, Korea added deepfake-related provisions to the amendments to the Special Act on the Punishment of Sexual Violence Crimes. This law stipulates three major provisions regarding deepfakes. First, a person will be punished if the person edits or synthesizes images or voice recording using deepfakes, and the outcome may cause any sexual stimulus or shame against the will of the subject person. Second, if a person distributes content created according to the previous provision, the person will be punished. Third, anyone who distributes such content for the purpose of making profits will be punished more severely. Not only the USA and Korea, but also many other countries have tried to enact regulations on AI in specific areas, such as deepfakes. For example, regulations on AI-based interviewing are already put in place in some states of the USA. On the other hand, legislation on overall AI systems was proposed for the first time in the world by the European Commission in April 2021. This AI Act, also known as AIA, is the result of a series of works that the European Commission has been preparing since 2018. In 2018, the European Commission established a high-level expert group on AI, simply AI-HLEC, to seek advice on AI strategies. In April 2019, this AI-HLEC came up with an AI ethics called Ethics Guidelines for Trustworthy AI, containing 7 core requirements. The European Commission officially adopted these guidelines. In February 2019, the AI-HLEC contributed to the publication of the White Paper on AI, a European approach to excellence and trust, and updated coordinated plan on AI. In July 2020, more than 350 organizations participated to compile the assessment list for trustworthy AI, simply ALTAI. After publishing the white paper on AI, a public consultation was launched online and ran until June 2020. During the consultation, opinions on the white paper were collected. In December 2020, the European Commission's Regulatory Scrutiny Board was convened. 4 months later, the board issued a positive opinion on the AI Act. And on April 2021, the European Commission published a proposal for the AI Act. The European Commission's proposal has specific objectives. First, the AI Act ensures that AI systems put on and used in the union market are safe and respect existing laws on fundamental rights and union values. Second, the Act ensures legal certainty to facilitate investment and innovation on AI. Third, the Act enhances governance and effective enforcement of existing laws on fundamental rights and the safety requirements applicable to AI systems. Finally, it facilitates the development of a single market for lawful, safe, and trustworthy AI applications and prevents market fragmentation. The proposal also represented several directions to achieve the objectives. First, it ensures that the AI Act should neither unduly hinder technological development nor disproportionately increasing the cost of placing AI solutions on the market. To this end, the proposal makes sure that the AI Act should set minimum necessary requirements for addressing AI-related risks and problems. It also presents principle-based requirements that AI systems should comply with. Through this, the proposal aims to establish flexible mechanisms that enable AI to be dynamically adopted. The European Commission's AI Act has great significance because it specifically stipulates the definition of AI from a technical point of view. AI systems are defined as software developed with one or more techniques or approaches listed in Annex 1. These techniques and approaches are broadly classified into the 3 categories. The first are machine learning approaches, including deep learning. The second includes traditional logic and knowledge-based approaches, including expert system. The third are statistical approaches. This AI Act comprehensively stipulates that AI systems can generate outputs, such as content, predictions, recommendations, and decisions. This enables the definition of AI to be interpreted legally and flexibly, even if AI advances in the future. This AI Act applies a risk-based approach to AI systems. AI systems are classified into 3 categories according to the risk level. First, an unacceptable risk. Second, high risk. And third, non-high, low, or minimal risk. And it creates regulating burdens only when AI systems are likely to pose high risks to fundamental rights and safety. Specifically, it judges that high-risk AI systems pose significant risks to the health and safety or fundamental rights of humans. Article 5 of this AI Act specifies what an unacceptable risk AI system is. There are 3 representative unacceptable risk AI systems. First, AI systems are unacceptable if they manipulate persons through subliminal techniques beyond their consciousness or exploit vulnerabilities of specific vulnerable groups, such as children or persons with disabilities. Second, AI systems are not accepted if they conduct social scoring of persons and groups for general purposes by public authorities. Third, AI systems are unacceptable to conduct real-time remote biometric identification in publicly accessible spaces for the purpose of law enforcement. The manufacturing and use of such AI systems is not allowed, and any violation should be subject to a severe penalty. With regard to this AI Act, the European Commission has the greatest interest in high-risk AI systems. This Act specifically defines our high-risk AI systems and presents the requirements high-risk AI systems should comply with. High-risk AI systems are largely classified into two categories. The first are AI systems used as a safety component of product that are subject to third-party ex-ante conformity assessment. The second is standalone AI systems that could pose a threat to fundamental rights, as explicitly listed in Annex 3. A total of 8 AI systems are listed in Annex 3 as the second category of the high-risk AI system. The first is an AI system that is used for the biometric identification and categorization of natural persons. The second is an AI system that is used to manage and operate critical infrastructure, such as road traffic and the supply of water, gas, heating, and electricity. The third AI system determines the access to or the assignment of educational and vocational training institutions. The fourth is an AI system that is related to employment and employee management and determines recruitment or selection of natural persons and promotion and termination of work-related contractual relationships. The fifth one is used to evaluate the suitability of natural persons to certain public services or calculate credit scores of natural persons. The sixth AI system is used by law enforcement authorities to assess individual risk, detect emotional state, profile natural persons, detect deepfakes, and evaluate the reliability of evidence. The seventh is an AI system that is used by competent public authorities for migration and asylum and border control management to assess individual risks of natural persons, detect the emotional state, verify the authenticity of travel documents, and examine application for asylum, visa, and residence permits. The eighth is an AI system that is used by the judicial authority to research and interpret the facts and laws and apply laws to a concrete set of facts. These 8 AI systems are categorized as high-risk systems. Before placing a high-risk AI system on the market, its provider must comply with strict obligations. First, the provider must prepare adequate risk assessment and mitigation systems. Second, the provider has to offer high-quality data set to minimize risks and discriminatory outcomes. Third, the provider has to log activities to ensure traceability of results. Fourth, the provider should enable detailed documentation that provides all information on the system necessary to ensure authorities can assess the system's compliance. Fifth, the provider must offer clear and adequate information to users. Sixth, the provider should prepare appropriate human oversight measures to minimize risk. Seventh, the provider has to ensure high-level robustness, security, and accuracy. Eighth, the provider must obtain the CE marking to indicating the conformity of the AI system with the requirement of the AI Act. Article 10 of the AI Act specifies the data governance that high-risk AI systems must abide by for training, validation, and testing data sets. First, AI systems should be developed based on data sets that fulfill the quality criteria. For example, specific data related to tasks such as relevant data preparation, processing operations, and examination in view of possible biases should be conducted in advance. Second, the data set should be subject to appropriate data governance and management practices. Third, the data set shall be relevant, representative, free of errors, and complete. Any violence of such data governance should be subject to a severe penalty. Any distributor, importers, users, or other third party are considered a provider in some circumstances. In 3 cases, where they put a high-risk AI system into market or into service under their name or trademark, and where they modify the intended purpose of a high-risk AI system already placed on the market or put into service, and where they make a substantial modification to the high-risk AI system, they are considered a provider and required to conform to the obligation of providers. Not only high-risk AI system providers, but also users are subject to obligations. In order to comply with the obligation of users, first, users have to exercise control over the input data. They have to ensure that input data is relevant in view of the intended purpose of a high-risk AI system. Second, users should monitor the operation of the high-risk AI system on the basis of the instructions of use. They also have to interrupt the use of AI system and inform the provider or distributor of any serious incident or any malfunctions when they have identified it. Third, users have to keep the logs automatically generated by that high-risk AI systems as long as such logs are under their control. The AI Act also provides recommendations on non-high-risk AI systems. First, providers of non-high-risk AI systems are encouraged to create a code of conduct with the aim to foster voluntary application of the mandatory requirement applicable to high-risk AI systems. Second, providers of non-high-risk AI systems may create and implement the code of conduct themselves. Those code of conduct may also include environmental sustainability, accessibility for persons with disability, stakeholders' participation in the design, development of AI system, and diversity of development teams. Basically, as for non-high-risk AI systems, very limited transparency obligations are imposed. In order to promote and protect innovation. The AI Act includes provisions that specifically give consideration to the interest of small-scale providers and users. According to the provisions, EU member states should provide small-scale providers and startups with access to the AI regulatory sandboxes. To this end, they have to establish a dedicated channel for communication with small-scale providers and users, and response to queries about the implementation of the AI Act. They should also prepare activities to raise awareness of the Act. The member states' competent authorities that have established AI regulatory sandboxes should coordinate their activity and cooperate with other member states within the framework of the European Artificial Intelligence Board. The European Commission's AI Act sets up the governance systems at the Union and the national level in order to promote a smooth, effective, and balanced implementation of the Act. The proposal for the AI Act stipulates the establishment of the European Artificial Intelligence Board. This board will be composed of representatives from the member states and the European Commission. The implementation of this AI Act is expected to take some time because it will require follow-up procedures, including the approval from the European Parliament. Article 71 of the AI Act specifically stipulates the penalty for non-compliance. Penalty for unacceptable risk AI system is specified in Article 5, and the penalty for non-compliance with regulations on the data governance of the high-risk AI system is provided in Article 10. In this case, you have to pay 30 million euro or 60% of your company's total worldwide annual turnover for the preceding fiscal year, whichever is higher. For non-compliance with regulations other than Article 5 and Article 10, you must pay 20 million euro or 4% of your company's total worldwide annual turnover for the preceding fiscal year, whichever is higher. If you provide incorrect, incomplete, or misleading information in reply to the request of notified bodies and authorities, you must pay 10 million euro or 2% of your company's total worldwide annual turnover for the preceding fiscal year, whichever is higher. The European Commission's AI Act is proposed for the first time in the world amid the growing need for regulations of AI systems. Therefore, it will have a significant impact on the global AI market trend. In addition, it is expected that this AI Act will be used as an important reference for the enactment of AI regulations around the world. During this lecture, we have learned about deepfake-related laws, mostly with our focus on actual cases. In the United States, a disclaimer is required when you use deepfakes. In Korea, a person who uses deepfakes in sexual assault crimes is subject to severe punishment. The AI Act proposed by European Commission for the first time in the world has some characteristics. First, it provides a specific and technical definition of AI systems. According to the Act, all AI systems are broadly classified into three categories, depending on their risk level. AI Act specifies what an unacceptable risk AI system is, and such systems are subjected to a huge penalty. AI Act mainly focused on regulations of high-risk AI systems. For high-risk AI systems, data governance is particularly emphasized. Non-compliance with data governance is also subject to a severe penalty. The Korean National Assembly is also discussing the possible enactment of AI-related law. It is expected that many countries will discuss and enact AI acts. In general, when the discussion of AI ethics matures to some extent, AI laws are anticipated to be implemented and take hold as minimum requirements for AI. Therefore, we have to prepare not only for AI ethics, but also for AI laws. This is the end of my lecture. If you want to know the content mentioned in this lecture in more detail, please find the materials or websites listed in the following references. Thank you for your attention.